So we're in front of the court here today on State of Ohio versus James Lane. And both sides will have 15 minutes to present their arguments. And the appellant will have 5 minutes for rebuttal if you so choose. I just want to tell everybody and remind everyone as we proceed today that that Apple changed their lightning cable, and it's driving me crazy because now we have 2 different ones on the bench and I have to figure out which one is which. I apologize. Anyway, we are going to be recording everything. It will be videoed, and please do not use the names of victims. Please do not use the names of minors. You can refer to the person as the prosecuting witness, as the victim, as the child, whatever, but we don't use their names. And so we're ready to proceed, and I will try to be watching the time. Just please let me know if you want to reserve some time. Thank you.
Thank you, Your Honors. May it please the court, Andrew Karras on behalf of the appellant James Lane. I would ask to reserve 4 minutes of my time for rebuttal.
Thank you.
120 days after James Lane was convicted, the victim in this case was 13 years, 8 months, and 26 days old, and in the custody of a grandparent who referred this matter to police for criminal prosecution. The question in this case is whether Lane could have by then discovered her desire to recant. On this record, the answer to that question I submit is clearly and convincingly no, and this court should accordingly reverse and remand. Criminal Rule 33 motions are ordinarily due when premised on the discovery of new evidence within 120 days after the verdict, unless the defendant was unavoidably prevented from discovering the evidence on which he relies. And the standard for what it means to be unavoidably presented, just quoting from this court's decision in the Covender case, is that the defendant has no knowledge of the existence of the grounds supporting the motion and could not have learned of it in the exercise of reasonable diligence. So applying that test here, the question is, could Lane, in the exercise of reasonable diligence, discover the victim's desire to recant 120 days after the verdict, that is on or before January 24th, 2017? I submit that the answer to that question is no, but before I talk about why, I want to emphasize that the trial court didn't exactly answer that question. Instead, what the trial court answered was something closer to, could Lane have discovered the victim's recantation sooner than he did? Which, since the Supreme Court's decision in State versus Bethel, that's 2022 Ohio 783, a case we've cited in our brief, is not the test. Some courts historically applied a reasonable diligence requirement even after the expiry of that 120-day window provided in Criminal Rule 33B. But in Bethel, the Supreme Court rejected that requirement as unmoored from the rule's text. Indeed, that has been this court's rule for even longer than that. Again, quoting from Covender, this court rejected an argument that after the 120-day window has closed, a subsequent discovery of new evidence requires the defendant to prove that he was unavoidably prevented from discovering the evidence any earlier than he did.
Counsel, in this particular case, though, as I recollect, the defendant doesn't have an affidavit, right?
The defendant, Mr. Lane himself, did not submit an affidavit. That's correct.
The victim did. So he has averred that he could not discover this information.
Not as
120 days.
Not as a sworn matter. He has not made that averment. Now, in filing his 33B motion, there is, at least as a matter of the pleadings, a statement that, describing the circumstances under which the victim came to Mr. Lane's family around the time she was 18 years old, that together they went to the police, that the Conviction Integrity Unit referred them to the Bar Association, and eventually they were referred to Mr. Lane's 33B counsel. Now, conceitedly, none of that is sworn matter below, and to the extent that this court, to the extent that the trial court found that some sort of affirmative duty to demonstrate pre-120-day investigative steps occurred, I would submit that that's just a misunderstanding of the Supreme Court's holding in the Johnson case. So Johnson, to be sure, says that the date that a victim's recanting affidavit is executed is not itself controlling as to when that evidence is discoverable. I agree with that. I think that's a correct and fair holding. But in Johnson, the Supreme Court was, at pains to say that Johnson exclusively relied on the affidavit, and here there are other surrounding circumstances, to wit, the evidence presented at trial that indicates that, even with the affidavit lacking some of those features, and even in light of Lane not submitting an affidavit himself, there are circumstances that, under logic this court has applied before,
Counsel,
make
is
it. Sorry.
The record, is there anything in the record that would show us that there's evidence regarding Lane's diligence and unavoidable prevention from discovering VA's recantation in a timely fashion? Is there anything there?
So again, in a timely fashion means, under the rule means prior to
Right.
VA's 14th birthday.
Okay.
And so this court has, in previous cases regarded it as self-evident, quoting again from Covender, for obvious reasons, while the defendant was incarcerated and the victim remained a minor, the defendant was not in contact with the victim or the grandparents who raised her after she was removed from her mother's care. So it's, I would submit, just like in Covender, within the province of being self-evident that a defendant is not required under Johnson, under the plain text of Rule 33B, to essentially ask a minor victim of a sex crime in the wake of a trial, were you lying when you testified?
Let me ask you this. Let's say we get past that issue, okay? The affidavit itself, the court remarked about, and in reviewing the affidavit, it seems to be the case that it's just very conclusory. Almost like, let's go through every possible element of a sexual offense and make sure that we say no sexual contact, no sexual conduct. That's not usually how a victim speaks.
So if your point is that, recanting victims often execute these documents with the aid of counsel, and oftentimes with the aid of a defendant's Rule 33B counsel, I think that's correct, that is often the way it works.
But there's really not a lot of facts, is what I'm trying to say.
That the affidavit is relatively sparse. And to be sure, that was, the sparseness of the affidavit was something the Supreme Court in the Johnson case noted. But what the Supreme Court didn't say in Johnson is that had there been other materials of record supplementing the affidavit, explaining why in this circumstance obtaining this evidence within 4 months of the verdict is just substantially impossible,
But
that the
counsel,
failure of the
was-
affidavit to include that is
but
controlling.
But counsel, that was not included, just so I understand, was not included in an affidavit from the defendant.
Correct. Now, there is no defendant affidavit in this case.
Thank you.
But to that point, I mean, Judge Carr, you yourself raised this concern in, I think, under a month ago in the Cunningham case. That's not cited in our brief given its recency. It's 2025 Ohio 4819.
And I'm very familiar with that case, but you're supposed to file a leave for new notice of new cases
Understood.
before you argue it.
Understood.
So let's just move on.
Okay.
Thank you.
But so perhaps contrasting that with the Johnson case. The Johnson case, did not involve a minor victim. It was not a sex crime, and the recantation at issue in Johnson was not equivocal. And what is really going on, so brief the point of, is there a difference between, equivocal recantation and one that is more qualified, or an unqualified versus more qualified recantation. And what I'm kind of getting at with that point is, so for instance, in the majority opinion in the Cunningham case, the court faulted the defendant for not taking specific investigative steps within that 120-day window.
Counsel, I'm sorry, but I just instructed you not to argue
Understood, I
in that
apologize.
case. I'm sorry, but you have not filed any notice, and it's not fair to the state.
Correct.
Now, that doesn't mean for everybody present that the court doesn't do its own research. It's just a matter of he hasn't had a chance to respond.
Understood. Thank you.
So if he tries to rely on that, I'm going to tell him the same thing. Okay?
Understood. But the point is that the 120-day window in the text of Rule 33 contemplates that ordinarily things occur at trial that might give a defendant, a reason to understand that there is evidence that hasn't been discovered in, ordinary pretrial investigation. And here, while there's no specific, attestation to I did these things within 120 days of the verdict, there are the trial transcripts which indicate that, the trial counsel did, in a sense, test the victim's willingness to recant insofar as he cross-examined her trial testimony, her direct testimony. And so again, understanding Johnson to contain a requirement that there is a specific duty to track down trial witnesses, ask them if they lied essentially in trial within 4 months of the trial occurring is not what Johnson says. I think a construction that would find that to be the case is likewise unmoored from the text of the rule. And consistent with this court's decision in Covender, when you are dealing with less than 14-year-old victim of a sex offense, it is within the province of being self-evident that you can't discover that kind of evidence within 4 months of trial.
You're at 4:40 if you want to change, if you want to save that.
Okay, I would reserve the balance of my time for that. Thank you.
Good morning, Your Honors. May it please the court. My name is Rick Braley. I'm appearing today on behalf of the appellee in this case, the state of Ohio, and Summit County Prosecutor Elliot Kolkovich. I think that this is a relatively quick case to dispose of based on the entire lack of evidence about any diligence.
Well, let me just ask you to start out with. So is your argument because he didn't say I couldn't have discovered this in an affidavit within 120 days, we just deny it?
No, I wouldn't say that, Judge. What I'm saying is there has to be some sort of evidence, so not just something that's written in a pleading, evidence, indicating that there was reasonable diligence to obtain evidence in a timely fashion.
But aren't you then asking defense counsel and defendants to basically contact prosecuting witnesses, victims, and say, hey, is there any chance you're going to change your testimony? I mean,
Right.
I think they're going to get in trouble for doing that.
Well, yeah, I don't know if they get in trouble for doing that. It's an investigation. That's what they have a right to do. I would say that there are examples of...
Well, I would get a temporary restraining order, an actual civil protection order against them.
Then
if I were the victim, but I know my rights, not everybody does.
If there is certainly a CPO in place that was in evidence, that clearly that'd be a great indication that they're tried, but there's no reason that they couldn't.
But in this case, it's even worse because it's a child.
So they could have reached out to the grandmother. Also, in a day of social media, there could have been monitoring of social media about any equivocal feelings that the victim may have had. I mean, there are constantly times after a trial where we hear new evidence from people. There could be discussion with other family members, some sort of evidence of something that was done. Here we have evidence that nothing was done. And in fact, the defendant in this case is trying to ask you to excuse that and say, actually, I get an exception to that because it is a minor victim, because I don't have to do any diligence, and that's not what the law says for that.
Would it make a difference if the defendant had stated in an affidavit that the reason why there was no contact was because of the reasons that are asserted here today?
Potentially. I think when a defendant would do it, there are some self-serving issues that I'd probably raise if that was the case. There's also a possibility for trial counsel to execute something. There could be family members to execute something, indicating that something had been done or that was considered, and there was a reason for why they didn't do this. For here, it just seems as though the case ended, there was a verdict, and everything stopped. And that's what, that's why there is this 120-day time period. If we want to get rid of that, there has to be a rewritten rule on that, but that rule doesn't exist.
I understand, but I think there's also, as counsel for the appellant has said, there's some case law that talks about certain things are just self-evident, that you just can't do it without either violating the law or just being plain creepy and causing distress to victims.
I don't know.
I can't even imagine the defendant constantly calling me and saying, do you want to change your testimony? Are you still thinking the same way? Are you still believing the same way? Are you sure that's what you believe?
Of course, there was harassing continuous contact after you try once. That'd be a real problem. I think that there should be evidence of something being done, some sort of monitoring. And I would point to, I think that the Ohio Supreme Court has given controlling guidance on this to Johnson. And there they point out, there's no information in that victim's affidavit about what was done. That's exactly what happened here.
And that's why my initial question to you was, is it just because he didn't say anything and didn't present an affidavit and didn't say, I in reasonable good due diligence could not have found this information within 120 days?
If that would have been provided, I might be in a little bit of trouble. But that does sound conclusory. I would still want to hear, what did you do? Because there is that requirement for diligence.
What about the actual affidavit here? If we get past the 120-day thing, the court made a point about the fact that the affidavit from the victim herself was pretty conclusory, not really fact-based in any way.
Yeah, so the trial court mentioned various deficiencies that were in that. I mean, that could go to the credibility of assertions in that affidavit. I really, in my analysis, I don't get into that because I just don't see any evidence about the unavoidable prevention issue. So I really hadn't thought about that at this point. If leave was granted and we were starting to talk about the credibility of that affidavit, I'd certainly start bringing that up.
And the other thing is, all this does is allows them to file a motion for a new trial. So, it's not like he granted a new trial, it's just a matter they can file a motion for a new trial.
Correct, but now the standard for leave in new trial is very different than other situations where you ask for leave. It's not good cause, it's not freely and liberally granted, it's you must give clear and convincing evidence. And that's to ensure that we have the finality of judgment in this state. A conviction is not a beginning round of a fight, it should be the end of the case with your direct appeal after that. So there's only really extraordinary circumstances where leave should be granted because when a motion for a new trial is filed and it's considered by a court, that leads to potentially evidentiary hearings, which leads to more issues of bringing in victims and witnesses, and that's not what our system is designed to have. So I've went through that. I believe Johnson is going to be controlling to this case. I think that they're very similar. I really don't think this court's Cavender case, I'm not sure if I'm pronouncing that correctly, is very applicable to us because of the very unique circumstances there about an in-camera review of records. And the court said this does not include exculpatory information, and later that turned out to not be the case. There was an actual diligent, reasonable effort to get the evidence in front of somebody. That doesn't exist here. And the last point that I would like to just bring up to the court's attention is I don't think the trial court used this reasonable time filing requirement standard that existed in some courts before Bethel. I think that all of the evidence that the trial court cites to and the deficiencies that the trial court points out in the affidavit relate to the lack of evidence about unavoidable prevention. There is no citation to that requirement. There is no finding that there was no reasonable time. So I think based on that, I would reject the pre-Bethel standard argument that Mr. Lane has raised. So with that, if there are no questions, I'd ask you to affirm.
Thank you.
Thank you, Judge.
And you still have 4 minutes and 36 seconds.
Thank you, Your Honor. So, I want to start by pointing out what might sound like a fine distinction, but I think it's a significant distinction. Counsel for the State has suggested that there needs to be some evidentiary indication of what the defendant affirmatively did within 120 days in order to avail yourself of the exception to the time bar in Rule 33. And the notion that there has to be a demonstration of diligence, I don't think is supported by the rule because whether you are unavoidably prevented can be demonstrated, to be sure, by you attempting to do something and you being prevented to do by it, being prevented from it necessarily. But as I've said previously, there are circumstances where it is just self-evident that something would be futile, that something might be harassing, that something might itself be criminal. And I would submit in this that we are in that territory in this case. Now, to just circle back on something about the perhaps legalistic nature of some of the affirmance in the affidavit, the credibility of the attestations are, to be clear, not an issue at the motion for leave stage. So the fact that it sounds like perhaps the victim is tracking the language of a statute in making certain attestations, that would bear upon her credibility at the merits of a motion for new trial, perhaps, but not at the motion for leave stage. Finally, a point about the Covender case. I would agree that the kind of unique circumstances of the trial court's initial faulty in-camera review of the therapy records that were at issue in that case is one reason the defendant was unavoidably prevented from procuring those records. But that's not where this court left its analysis. It also said, well, the other way he could have gotten at that evidence was to talk to the witnesses. And in this case, the witness in question was a minor and was in the custody of parents who referred the matter for criminal prosecution, as in this case. And this court said, with respect to that potentially available avenue, that it's essentially self-evident that that is evidence that you are unavoidably prevented from acquiring. And unless the court has further questions, I would rest on the basis of a brief.
I don't believe so. Thank you so much.
Thank you.
Thank you both for your presentations to the court. The court will take the matter under advisement, and we will issue a written opinion that will be sent to both sides, as well as electronically it will be released on the Ohio Supreme Court website. So thank you all very much, and try to have a good rest of your day.
Thank you, Judge.